Saturday. It is the third Saturday of the month, which means it is time for Right to Know updates. I am now president of Right to Know New Hampshire. I just recently took over that role. So, first of all, I have to do my mea culpa and be like, the best laid plans sometimes just don't work out. So I had sent all my information out using the Zoom link, but I didn't realize that that did not actually go to the group. And so today was a bit of a mad scramble. Why am I mentioning that? Because I think it's important for people to understand, even when you are taking on lots of leadership roles and getting involved, things can go wrong, and you just kind of need to learn to roll with the punches. So today's Saturday. I hope everyone is having a fantastic day. Today is day 291 of my living experiment. So that is where I jump on X Live and have been doing that for 291 days straight. So if you're following me for that, welcome back. Thank you. Great to see you guys. 291 days straight, by the way, is 9 months and 18 days of doing something. Why am I doing this? I'm doing it primarily to learn about my own routines, vices, virtues, successes, failures. And honestly, I'm starting to think it's a giant art project in order to hone my voice to become a stand-up comic. It's going to happen. All right, half seriously though. Artsy Fartsy, which is a Free Stater-led event that has been taking place for probably 15 years now, will be taking place next Friday at the Quill here in Manchester, New Hampshire. And I am publicly committing over here to be like, I'm going to do 5 minutes of real stand-up. Why am I saying real stand-up? Because I have attempted and bombed and done some, hey, I can tell funny stories, but maybe, as I learned after I bombed at Porkfest, I should write some jokes. So I'm going to try and do that. So today I want to, and then other things that are coming up today. First of all, there is Market Day at the Quill. Emily from Barda Farm brings in her meat. There is some farmers who bring beautiful flowers, really good produce. I just have finished with the kale, delicious stuff, and other tchotchkes and things. So if you're in the Manchester area, please do come to Market Day. And I will, on Mondays, as I always do, update everyone on what else is coming up in the Free State this coming week. But today is Right to Know Day. And I had house guests who are Free Staters, but they snowbird, so they're heading back down to Florida. And I casually said, right to know. And the gentleman was like, what is that? So I thought, okay, let me just quickly explain to everyone. Here in New Hampshire, we have a constitutional right under Part 1 of Article 8 of the New Hampshire Constitution, which says accountability of magistrates and officers, the public's right to know. And we have a really good, and I'm going to read all of it in a second, wording in the Constitution around it. Why am I mentioning constitutional right to know? Because we also have an RSA 91A, which is our right to know law here in New Hampshire. But sadly, what has happened over time is we have started to reduce our constitutional rights to access to open and transparent government is being eked away by this 91A exception, where they are putting in more and more stuff. The more stuff you write down in these contexts, the more it happens that you need more lawyers, you have more confusion, it's all bad. And so I really want to get our focus back onto the constitutional rights that we have under the New Hampshire Constitution. So what is that? Article 8 says, all power residing originally in and derived from the people, that's us, all the magistrates and officers of the government are their substitutes and agents, and at all times accountable to them. Government, therefore, shall be open, accessible, accountable, and responsive To that end, the public's right of access to governmental proceedings and records shall not be unreasonably restricted. The public also has a right to an orderly, lawful, and accountable government. Therefore, any individual taxpayer eligible to vote in the state shall have standing to petition the Superior Court to declare whether the state or a political subdivision in which the taxpayer resides has spent or has approved spending public funds in violation of the law, ordinance, or constitutional provisions. So basically, we have a constitutional right to open, accessible, transparent, and accountable. That's the important part. It doesn't help we know what they're doing if we can't actually hold their feet to their fire, which sadly, most of the time we can't. If you really want to go down a frustration spiral, start asking the AI to list examples of when the government has ever been reformed, and then perhaps you will start to decide to spend your time differently. So a couple of things. This is the Sunday paper that came in a little earlier. I just thought this was funny because look at this photo of both the these are two mayor candidates. Obviously, currently we have Mayor Ruiz, Jay Ruiz. He's been pretty good, except he did vote on a bond that's very bad for the city. But I was struck by how they both have their arms folded. And of course, this is supposed to be a power pose. But if you know anything about human body language, that is a very negative way to approach your constituents. And so I was very struck by that because, of course, it is a defensive thing, and it says you're not really open or not really interacting. So that was interesting. So what I'd like to do now is I am going to read an article that was in yesterday's paper, written by Lori Ortolano, who serves with me on Right to Know New Hampshire. She is an amazing open government advocate. She is an amazing voice out there trying to keep Nashua, the city of Nashua, south of us here, honest. She has also done so many court cases now that she knows the judiciary pretty well. And she and I have both been looking at the developments going on and kind of just shaking our heads and wondering what's happening. Amongst other things, there was a scandal in the judiciary where a Supreme Court justice had to be taken off the Supreme Court because she was like doing insider dealings to protect her husband, who was also charged with some crimes. And her whole thing, she just pled guilty this week to being like, yeah, I was totally unethical. And then the next day they put her back on the Supreme Court, which should not happen. And so I think Lori was sort of commenting on all of that. I also don't want to be remiss in not reminding people the Naki Loeb First Amendment Award ceremony is coming up next Thursday, the 23rd of October. It's taking place at 4 p.m. at St. Anselm. The tickets are $75, and you could go to Naki Loeb. Just Google Naki Loeb. That's NACKEY LOEB, Naki Loeb Award, and I'm pretty sure you would get there and grab your tickets and come support true First Amendment activism in the great free state. All right, I think that's everything I needed to remember. So now I'm just going to straight up read Lori Ortolano's excellent words. Lori lives in Nashua. She has won several First Amendment awards over the years. She has done several Supreme Court cases where she has had bad Superior Court decisions overturned. She is truly, for me, one of my personal heroes, relentless, dauntless, and just a wonderful voice here in New Hampshire for open, transparent government. So these are Lori Ortolano's words, but I wanted to share them so that people can hear them if they're following me as well. All right. Public confidence in New Hampshire's judiciary has been shaken. Last week, the New Hampshire Attorney General's office accused sexual abuse survivors of undermining confidence in the judiciary for merely questioning whether the judge who ruled against them had been nominated by Governor Kelly Ayotte for the Supreme Court seat. This week, the same office facilitated the return of a convicted justice to the very bench those victims were told not to question. Together, these episodes reveal a deeper crisis, a judiciary that punishes those who question its integrity while protecting those who have demonstrably breached it. How the door was held open. Under Supreme Court Rule 37-9B, automatic disciplinary suspensions apply when a lawyer or a judge is convicted of a serious crime. Justice Anna Barbara Hans Marconi's plea to criminal solicitation for the misuse of position was deliberately structured to avoid that designation. The plea agreement explicitly stated that her offense was not a serious crime, even though it involved influence peddling with the governor's office on behalf of her husband. That phrasing allowed her to retain her law license and immediately resume judicial duties once the court had accepted the plea. Attorney General John Formella, who negotiated and approved the agreement, publicly called her conduct unlawful and unethical and a serious breach of public trust. Yet the very deal his office endorsed ensured no meaningful delay in her reinstatement. The AG's statement sounded like accountability, but the design of the plea ensured there would be none. A substitute panel of justice acted with stunning speed, reinstating her license and clearing her docket for new cases by Wednesday of the same week. This week, by the way. There was no public explanation of the decision, no statement addressing the appearance of impropriety, and no imposed cooling off period while the related disciplinary matters remained pending. Procedurally permissible? Yes. Institutionally wise? No way. The optics. The judiciary's authority rests not only on legality, but on legitimacy. Watching a justice convicted of using her office for personal advantage return to the bench in 72 hours sends a corrosive message. Rules apply differently to those at the top. Labeling the offense a non-serious misdemeanor didn't lessen its ethical gravity. Rather, it exposed a culture of self-protection inside the state's highest court. That contrast is amplified by Senior Assistant Attorney General Samuel Garland's rebuke of the YDC survivors for simply asking about judicial impartiality. His office called their questions entirely inappropriate, yet when a Supreme Court justice pled to political favoritism, the same office fast-tracked her reinstatement. Citizens who question bias are scolded. Judges who prove it exists are back on the bench before the week is out. No confidence vote. This episode should shake public confidence to its core because it exposes the judiciary's dual standard. The judicial code emphasizes not only fairness, but the appearance of fairness. The AG and the justices who approved Marconi's swift return ignored that appearance entirely. There was no public reasoning, no acknowledgement of the damage that was done to perception, and no indication that the institutional trust outweighed institutional loyalty. In any system that claims integrity, even a hint of favoritism should trigger restraint. Yet here, a proven act of favoritism was brushed aside before the weekend. To restore trust, transparency, humility, and time must replace secrecy and speed. Until New Hampshire courts value those over convenience, a vote of no confidence is not only justified, but necessary. Honor cannot live in a system that protects itself first. What more accountability looks like. If New Hampshire's judiciary wishes to regain trust, it must show that integrity matters more than expediency. Real accountability would mean public written explanations for any reinstatement following ethical or criminal violations. 2, mandatory cooling off periods before judges return to duty after misconduct. 3, transparent tracking of Judicial Conduct Committee and Attorney Discipline Office cases. 4, expanded recusal rules for reinstated judges in cases involving the executive branch or political actors. And 5, Rule 37(9)B reform to ensure any conviction for misuse of public office, even a misdemeanor, triggers an independent review. These steps, so these 5 steps, will not erase the damage, but they would signal that the courts take their legitimacy seriously. Condemning victims and citizens who exercise their right to protected speech, to question judicial fairness, only deflects from the real issue. Accountability cannot come from quiet deals and quick returns. It comes from transparency, courage, and the willingness to place public confidence above institutional convenience. If ever there was a moment to examine the words confidence in the judiciary, this is it. So my deep thank you to Lori Ortolano. This is Lori Ortolano's article that is in yesterday, so Thursday's Union Leader here in New Hampshire. Again, we cannot expect the courts to function well and function as a third part of government if it's all an inside job, which is pretty much what it is. All right, so thank you all for joining me for today's MLX. That's My Living Experiment, day 291 here on X. This afternoon, there's Marketplace at the Quill. There's 100 other things going on, as there always is. Go to fsp.org/calendar if you want to know what's going on in the state from a libertarian, liberty, free stater perspective. And tomorrow is Sunday, so I will be back here with something to talk about. I usually try and do something a little spiritual on Sundays, so do jump on and join me if you see my face coming past in your X feed. Thank you to everyone on X. Thank you to everyone on YouTube and Facebook. I will be back again tomorrow. Peace out.